next matter to come before us this morning is in re ES, KS, and GS. I see that the applicant has waived, so you will have 15 minutes to present oral argument. Please don't use the names of any victims or minor children, as we are, as you know, recording this oral argument, and it will be posted on the court's YouTube channel. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. Attorney David Lowry for the appellant 0031017. In some respects, I feel a little honored this morning because the previous case dealt with the Wilson case, which was actually my case that I had the opportunity to argue to this honorable court that made the right decision sending that back to the trial court. So with that said, I guess it's a small world. This case, I think, is an interesting case, and I have two assignments of error. I don't know if this court may or may not. I prefer to argue the issues of law. I figure that the court can read a transcript and sort of figure out issues of fact. Assignment of error is more of a factual assignment that presents the issue of whether or not there was a change in circumstances that would be required in order to modify custody or possession of the children. It's based upon the fact that the singular issue of fact that the magistrate determined would constitute a change in circumstances was my client had a relapse. And the issue is that relapses are part of recovery. That's not a change in circumstance. When the court closed the case, the court acknowledged and understood that she had a significant drug problem and that she was going to continue with counseling and she was going to continue to do what she had to do in order to address that concern. I really couldn't find any cases in Ohio on the issue. I think I cited a couple cases out of Iowa, maybe in California. But I think it's an interesting argument. I think it's one that's right for consideration. I cannot find any case law in Ohio that stands for the singular proposition of whether or not having a drug overdose as part of a relapse would constitute a change in circumstances. Because the magistrate in this case clearly said, listen, this is a closed case. I'm going to discount everything else I heard, and the sole and singular issue that I think would constitute a change in circumstance would be that relapse. So I think it's an interesting issue. I think it's more factual in nature. So I'd like to move on to assignment of error number one. Go ahead, I'm sorry.
Let me just ask you in regard to that, because it is an interesting issue. So relapse is obviously part of rehabilitation, you know, and everyone knows that, but at the same rate, this was not just a relapse, this was actual OD, where the parent almost died. Wouldn't that be a little bit different than just, you know, use of the narcotics or whatever?
Well, I suppose it would. I mean, you know, the problem, Your Honor, is that this court is abundantly aware, you know, the streets and the market is just flooded with fentanyl and drugs, the potency of which people have no idea. I've lost many clients, their children and friends, and people I've known, and it wasn't because they were intentionally trying to overdose. It was because they were trying to get high. And bad things happen when you don't know what you're doing, and the purity and you know, the fentanyl and the inclusion of fentanyl and the things that customarily, you know, the inclusion now of fentanyl into heroin, into methamphetamines, into, you know, marijuana. I mean, it's to sit here and say, well, gee, an overdose is different. I mean, I can guarantee you one thing, and that's that my client wasn't trying to overdose. She was trying to get high. And I think, I guess in response to your question, I think it's virtually impossible to draw that line. So I consider it to be the same thing, quite frankly.
Okay, thank you. I appreciate that.
Assignment number one error is interesting, very interesting, and I think it presents an opportunity for this court to correct the misperception in this juvenile court and other juvenile courts in the state of Ohio. I've shared the facts of this case and told other lawyers in juvenile court what I'm doing, and they look at me and they tell me I'm crazy. Because they say once a DN, always a DN. That's nonsense, and it's not true, and it shouldn't be true. This case involved a situation where there was an abuse, dependency, and neglect finding against my client. She worked diligently a case plan, and ultimately the children were returned to her. after the children were returned to her and lived with her for a significant period of time, there was this incident of drug overdose, which Judge Carr just mentioned. And as a result of that, the paternal grandparents came in and filed a motion. Now, the paternal grandparents came in and filed a motion under the existing case because the court retained jurisdiction over the child. It was couched as a motion under 2151.353, which I don't believe it was. I think it was a motion under 2151.23. But I don't know that that's the issue of how it was filed. It got before the court. The issue presented here, and there's a lot of case law floating around, but the case law establishes clearly, and all the cases that were cited by the magistrate and the judge, there's no doubt, in my opinion, that in the body of a DN case, while a DN case is pending, okay, that a finding of a dependency, neglect, or abuse establishes that element of in re paralysis, of either unsuitability or unfitness. I mean, there's a plethora of that. It's an in re, CR, in re DR. I mean, this court has spoken extensively on that issue. I don't think there's any doubt that within the body of an existing case, before the court issues a dispositional order in that case, that the test is best interest because the element that is necessary in paralysis has been established, and that's clearly stated, for example, in re CR. If the syllabus of the court, this is a Supreme Court case, in re CR, a juvenile court adjudication of abuse, neglect, or dependency is a determination about the care and condition of a child and implicitly involves a determination of the unsuitability of the child's custodial and or non-custodial parent. So within the context of an existing case, that establishes that component that would have been necessary in a private custody case under in re paralysis and the other Supreme Court cases.
Counsel,
yes.
Was in re paralysis a dependency and neglect case though?
No, it wasn't. No, it was not. It was a private custody case, which is what this is. And the reason why I'm saying what this is because these children were returned to my client.
But did you just speak to the statutory authority of the court to modify or terminate its
the court always has the authority to modify, but once the case is closed, okay, and you refile it, and here's the issue, and I try to succinctly point it out on page 14 of my brief, and I say, and if you don't mind me reading, but I said it here in words better than obviously I'm saying here, is that the issue before this court is whether in a case where there has previously been a dependency adjudication and closed with return to the parent, does a subsequent motion to modify brought by a non-parent, and that's very important, when it's brought by a non-parent, third party, does that invoke the statutory framework in 2131.353 and therefore eliminate the requirement of a preponderance of finding unsuitability? And does a prior adjudication survive the closure of the case? See,
I agree with you. That's a very well stated issue. The question is, was that argued below? Was it part of the objections to the magistrate's decision?
I unfortunately didn't do the case. If it would have, I would have. But I think that, well, I know, well, at least I believe. That was good. I think, I know, I believe. Anyway, this court has the ability to address, regardless of whether it was argued at the underlying court, if there is a misstatement of error or if the court adopted the wrong standard. At least that's my understanding of the law in the state of Ohio. So even though it should have been argued and alleged at the underlying case, it wasn't. But I think regardless that this court has the ability, because clearly it was the court used the wrong standard. In my opinion, there's no doubt. And the reason why I say that is I say the closure of that case, that eliminates that scarlet letter of the abuse, dependency, and neglect. And it has to start over again. Otherwise, what you're saying, if that's not the case, what you're saying is someone could have an abuse, dependency, neglect case from 15 years ago and get the children back, and then 15 years pass, there's an issue, a third party, a non-parent. If it's a parent, there's no doubt under point 4.2 that it's a best interest standard. Okay, there's no doubt. But if a third party comes in, to say that that third party can continue to rest upon the laurels of an abuse, dependency, neglect finding that was 15 to 20 years ago, even after there's been a closure of the case, the parent is returned, it's a fallacy. I mean, it shouldn't happen, and it can happen. It's not right. It's a and that goes to the constitutional argument of assignment of error number 2. That return of the child, in my opinion, and I think that this court should agree, and I think this should be in the law, and it's not. I can't find a case to point, which is what makes it interesting. But that closure of the case and return to the parent eliminates that presumption of unsuitability. Otherwise, the children wouldn't have been returned.
Counsel, I think, I'm sorry, I didn't want to interrupt you because I know you were very passionate about what you were saying. But I guess I want to make sure I understand your argument to be this is only solely relating to a third party.
Yes.
All right. So
certainly.
when this child initially went back to mom after a finding of dependency and neglect, the child went back to mom under the protective supervision.
There was a PSUP for a while, yes.
And then it was eventually closed.
Yes.
The case was closed.
Yes.
And there was no continued jurisdiction or protective services with CSP.
That's correct. No, the case was closed. The children were returned. The case was over.
So the court would always have jurisdiction of that child.
Of the child, right, exactly. And that,
So my question, I guess, is you're saying, and I don't want to put words in your mouth, but you're saying that CSB would not have to go back and show dependency and neglect again or abuse. It could come in and ask for legal custody to be changed based on a change of circumstances or whatever. Would that be still okay under your scenario? Because I'm a little confused. I understand the third party, but I guess I'm a little confused as to when that initial determination, it seems like you're also saying it ends for CSB too.
you're throwing me a curve because I hadn't really thought about that. I don't think there's any doubt with respect to a third party. I think, and if you look at the language of 4.1, it talks about whether or not it should. A talks about being returned to a parent. B talks about a person. There's quite a distinction there. I believe that even at CSB would have to come in and they would have to show there'd have to be an ETC, there'd have to be a finding of abuse, dependency, and neglect, and the case would have to start over again.
I'm just thinking of a scenario where, for instance, there's a person that's completely physically disabled and has to be under a doctor's care and because of a disease or whatever in a hospital, and so the child is neglected, or not neglected, but dependent at that point because of just the circumstance of the environment. It's nothing that the parent has done wrong. So there's a dependency finding. And then the parent completely recovers and takes the child back and the case is closed. And then there is something new happens, a change of circumstances. So I'm wondering there if CSB would be able to use the old case number and continue jurisdiction, or would it have to file for a new dependency and neglect, or new dependency?
Judge, I think constitutionally, from a constitutional standpoint, that the court can't label you with something and then live with that label for 20 or 30 years and then make a determination based upon a label that it obviously didn't exist at some point, because otherwise the children wouldn't have been returned. My perception is yes, that the CSB would have to initiate a new case. More than anything else from a constitutional standpoint, because you can't, I mean, it would be akin, it's akin to, like my client, it's akin to labeling her. You know, at some point the children were returned, and like with your example. So at that point, it's not the court saying, okay, the abuse, dependency, and neglect have been resolved, we're closing the case. Is it fundamentally fair to anyone, 5 or 10 years later, that the court says, hey, we just refiled. We previously found that there was an adjudication, that there was dependency, neglect, or abuse, so we're going to rest on our laurels from 10 years ago, and we're only going to proceed on a best interest test or a change in circumstances. No, it's not fair. It's fundamentally not fair. It's constitutionally intolerable. And in terms of your question, no, I think they have to start a new case. So,
Counsel, unfortunately, I need to let you know that you've utilized a little over the amount of time allotted today. Thank you very much for your
you can say I was well organized.
It was an excellent
I get
argument,
paid these
Counsel.
people come up with one pad of paper and notes.
We all
Anyway.
we all have a different style.
I know, I understand that. Thank you.
Court will take the matter under advisement. We will issue a written decision to
Thank you so
all
much.
parties to this appeal.
Have a good week.
You as well. We are adjourned until